The hearing will start now. This is originating application 881 of 2023, summons 2738 of 2023, Babel Holding Limited.
All right, good morning, Mr. Yo, Mr. Chan, Ms. Lee, Ms. Yo, and Mr. Xu for the applicant, correct?
Yes, Your Honor.
All right, and for Parastate, Mr. Chu and Mr. Tan, correct? Sorry, are you there? Mr. Chu Huai, Mr. Mark Tan?
Yes, Your Honor. I apologize. There's some system error.
That's all right. Thank you. All right, and I note the number of counsel for other parties. I believe no one else will be arguing this morning. Oh, sorry. Mr. Sean Chong from Meritus Law. Sorry.
Yes, Your Honor.
All right, thank you. All right, I believe the rest of you will not be arguing, but I'll come to you later. And the number of attendees as well in the virtual room. But let me administer first the Zoom allocution. So parties are reminded that there is to be no unauthorized photography or recording in any form, and no dissemination of any photographs or recording of these proceedings, and only those counsel or persons notified to the court should be present at each location. And parties should treat these proceedings as they would a physical hearing. All right, with that out of the way, thank you, Mr. Yo and sorry, Mr. Chu, for your submissions, which I've received. Now, Mr. Yo, first, a bit of housekeeping before we start. I suspect I will need to reserve for a couple of weeks at least. Any particular difficulties? Assuming, of course, I grant any interim moratoria that's necessary.
No difficulties, Your Honor, except that the scheme timetable which we had proposed would need to shift, and we will, of course, give creditors notice of any updated timeline.
All right. So I will take it that 2 weeks or so will not pose a fatal difficulty.
I don't believe so, Your Honor.
All right. All right, thank you. Let's begin then, Mr. Yo.
Thank you, Your Honor. Before Your Honor, you have 3 sets of applications.
Yes.
For convenience, I will refer to them as the sealing, the convening, and the moratorium extension applications. Your Honor, the proposed sequence, just some housekeeping. In terms of proposed sequence, may I propose to address the sealing first, the convening second, and the moratorium extension third?
Yes.
And the rationale for that, if necessary, Your Honor, is just if the court does not allow sealing, then the creditors should be given time to review any unredacted information before the convening.
Yes.
That's why the sealing should happen before convening.
Yes.
And moratorium extension lasts only because I suggest that, you know, the convening being allowed or not allowed would have a significant bearing on any moratorium.
Yes. What I will do is I'll hear you on the sealing, then I'll turn to, I believe Mr. Chu is taking a contrary position on sealing, so I'll turn to him first, and then so we'll basically sort out all the arguments on sealing first. Please proceed.
Thank you, Your Honor. Just a couple of other points on housekeeping. First, in the convening application prayer 6, we had sought the appointment of an independent assessor. Your Honor, I should update and be frank that there's a delay in the engagement terms being agreed with the independent assessor. So while the prayer 6 does not actually name an independent assessor, we are perfectly happy to write in if that is suitable and to Your Honor's liking after the hearing with the identity. Third bit of housekeeping, Your Honor, is in terms of who will be making submissions. With Your Honor's leave, may I have permission to make the submissions, but for my mentor and senior partner, Mr. Andrew Chan, to address 3 specific issues in the convening application.
All right, thank you. That's fine.
Thank you, Your Honor. So perhaps without further ado, if I may turn to the sealing application first.
Yes.
Your Honor, the sealing application is intended to seal certain letters of support which had been provided to the Babel Group. Your Honor should have before you a set of written submissions filed in 2738.
Yes. All right.
And I will be primarily referring to this. I believe we have gone through these sealing applications and authorities a couple of times before.
Yes.
But I realize it has been some time since we last addressed you. So I will try not to assume that anything is already accepted or taken as read. But I think the major point, Your Honor, is simply this, that the Babel Group had received requests for anonymization from numerous creditors who had provided letters of support. For that reason, after filing the convening application and having received those further requests thereafter, we then made this sealing application. And it is important, Your Honor, before we before parties perhaps overstate their either their reasons for or against the sealing application, I think the most important thing to flag is actually at paragraph 18 and 19 of our submissions. The most important point to flag is, and this is a requirement of law, and is certainly not covered by the sealing application, which is that under Section 68 of ERDA, read with Regulation 3, the chairman of a scheme, the scheme meeting, is required to send a copy of the list of creditors, the full list, to every creditor who has filed a proof of debt within 7 days after the period within which proofs of debt are to be filed. Your Honor, since we filed this written submissions at the end of paragraph 18, it states that the deadline is 21st September. Since then, that date has been moved to the 28th of September in the latest revised timeline. If Your Honor needs a couple of weeks or will be reserving judgment for a couple of weeks, then that date will shift by another 2 weeks.
All right.
So in reality, Your Honor, the sealing is sought just to make sure that when the list of creditors comes out, that everybody will be identified at the same time, and that nobody will, no creditor will be identified early and be subject to possible contagion risk at an earlier stage than any other creditor. That's the first point. And the second point, Your Honor, is that the rationale for holding back disclosure up to that date is, well, first of all, to make sure that everybody is identified at the same time. But secondly, to make sure that no creditor is identified at a stage where the convening application has not yet been granted. The reason for that is because the risk of contagion is higher when the restructuring is at a more nascent stage. So if, for example, there's a risk that Your Honor does not grant the convening application, then that leads to additional risk of contagion. Whereas if all creditors are identified at the same time, and second, that creditors are identified only after Your Honor has granted a convening order, if Your Honor so sees fit, then the risk of contagion is lessened.
All right.
So Your Honor, I think just with that as the broad framework, so that perhaps my sealing application is not misunderstood, that first of all, it is limited in time, and second is limited to this very specific purpose, to make sure that everybody is identified together, and only after convening order if so granted. I will then turn to the authorities.
Yes.
Your Honor, I will skip back to paragraph 7 of my submissions, and I don't intend to belabor this for very long. Your Honor has the power to grant sealing orders. This is well recognized in local authority. This has been recognized in BBW versus BBX, and I will highlight, of course, that the court's exercise of this inherent power was supposed to be in exceptional circumstances where there is a pressing need, and that the sealing order must be fundamentally concerned with a just outcome as well as the achievement of justice and the efficiency of administration. That said, specifically in the restructuring context, at paragraph 9 of my submissions, the court has the ability to strike a balance between the need to protect commercially sensitive information in restructuring and the need for transparency in those court proceedings. And Your Honor would be even more familiar with this case than I. In Rezitmex, Your Honor had held that there was a separate sealing application in relation to certain commercially sensitive matters relating to a share subscription agreement involving the investor. And Your Honor recognized, given the confidentiality required to move the restructuring forward and the absence of any apparent prejudice to the creditors, particularly as the document was disclosed to the court, I granted the sealing order sought. I will pause to note here, Your Honor, that every document that we have sought to seal has already been disclosed to the court. Your Honor, in Design Studio Group, at paragraph 11 of my submissions, the court had granted orders to seal certain documents to protect the identity of a financial services firm and potential financiers and proposed quotations. Again, the court observed there's a need to protect commercially sensitive information in restructuring, which the courts have to balance against the need for transparency. Your Honor, I don't propose to go through True Yoga as well. I will skip instead to foreign case law, which specifically deals with the sealing of the identity of creditors. That is at paragraph 21 of my submissions. And this is in Recred, where the Delaware Bankruptcy Court granted a motion to redact the names of customers on a final basis, where unredacted versions of a top 30 list of creditors and creditor matrix were provided to the court. And the court held, the court having determined the legal and factual basis set forth in motions, the court granted this order. The debtors are authorized on a final basis to redact the names, mailing addresses, and email addresses of their customers, as well as the mailing and email addresses of individual creditors on any document it files or makes publicly available in the Chapter 11 cases, including the schedules, creditor matrix, and top 30 list of creditors. Over the page, Your Honor would see that as part of the order, the court said, notwithstanding anything to the contrary in the orders relating to other matters in the Chapter 11, the claims agent is authorized on a final basis to suppress from the claims registry the names, mailing addresses of customers and creditors. And C, further down in that quotation, to withhold publication of proofs of claims filed by customers, provided that the foregoing documents in unredacted form shall be made available to the court, the U.S. trustee, and the proposed counsel to the committee. Your Honor will note that I am not going so far as to pursue C, that I am not seeking to withhold from publication proofs of claims. Singapore has a statutory framework which deals with that, and the sealing order sought herein relates only to letters of support. Your Honor, I will be the first to say that this order is just simply that, it is an order. It does not go into the reasoning for the above order. But I do note that the primary basis on which sealing was sought in the submissions filed, and we had enclosed a copy, was that public dissemination of the customer list would give customers, competitors an unfair advantage and interfere with the debtor's ability to sell assets and maximize value, and will place the debtors at a competitive disadvantage, and will needlessly place the individual customer's highly sensitive personal information into the public record. Your Honor, I will note that a similar order was made in Re FTX, to redact the names and addresses and email addresses of customers, creditors. Yona, I will skip ahead to I will just note on page 14 of my submissions, re-block FI, similar order was made to redact the top 50 list of creditors and the creditor matrix, names, home and email addresses, and etc. Again, this is an order, no elaboration on the grounds. It should be said that there is an adverse case, and we had highlighted this to Your Honor before. Sorry, before I turn to the adverse case, at the bottom of page 14 and the top of page 15, Your Honor will see Revoyager Holdings. There was another redaction allowed. And then on the top of page 15, matter of certain claims and notices agents in relation to a company called X-Claim Inc. Chief Justice Martin Glenn of the United States Bankruptcy Court for SDNY specifically said that protection of individual creditors' personal information in crypto cases has been the trend in the recent spate of crypto-related bankruptcy filings. These concerns materialized in the Celsius case as hackers emailed certain account holders impersonating debtors' counsel with illegitimate web links and seeking PII and information about their claims. And the court further cited further cases where it had been held that this risk is not merely speculative. During the debtor's prior Chapter 11 cases, for example, there was an abusive former partner who used publicly accessible creditor and employee information. So bottom line, Your Honor, is there are at least 4 or 5 different cases specifically involving crypto where redaction of names, email addresses, and home addresses of creditors had actually been allowed. I now turn to the adverse case, which is the Celsius case, which Chief Justice Martin Glenn had noted, where the United States Bankruptcy Court granted a sealing motion in part to authorize the debtors to redact names and addresses of individual creditors, but denied the motion to redact business entity creditors. And the court's reasoning in the adverse authority is set out at page 16, Your Honor. The court recognizes that in sustaining the U.S. trustee's objection to sealing, the court declines to follow decisions in several other recent bankruptcy cases. And it proceeds to list the earlier cases, some of which we have cited. But the court at the second paragraph says the strong public policy of transparency and public disclosure in bankruptcy cases requires very narrow exceptions and only on strong evidentiary showings. The court says that in the third paragraph, the court is not persuaded by the proposed solution to redact in part because the public schedules do not serve the interests of individual creditors, but rather also serve the interests of creditors and public in general. And all parties and the public share an interest in complete transparency with only the rarest of exceptions. So essentially, I think Celsius was very concerned that there be transparency in restructuring. Your Honor, we have provided reasons why we disagree with Celsius. We've said it's not representative of the law. It in fact runs contrary to the earlier cases we had cited. In fact, Block FI was one of the cases we cited to you, post-dated Celsius, and still decided that sealing was actually justified. We also agree more with the reasoning in the other cases than we do with Celsius. But I think the fundamental point, Your Honor, in this sealing application is really that the intention is only to seal for another 3 weeks if Your Honor is reserving judgment for 2 weeks.
Right.
So I think that is the fundamental point here, that the sealing is not intended to be for very much longer. I will now turn, Your Honor, to the objections which we had received to sealing. And the primary objection, Your Honor, appears to be that creditors will not be able to consult with each other. Your Honor, I think Parastate has objected on the basis that there is a need for scheme creditors to be able to consult with each other. Essentially, that's the one-line statement, if I may, of their position. Your Honor, creditors will be able to consult with each other at the scheme meeting, which is the very meeting which is designed for creditors to consult with each other and vote together. The question is, why is that need to consult with each other relevant at this stage? That brings me to the second.
Sorry, Mr. If I could just stop you there. I mean,
Yes.
while the meeting is one venue, my assumption has always been that they will be they would want and be able to consult with each other even up ahead of the meeting, so to speak. So
Yes.
if I were to grant your sealing application, won't that actually narrow things down considerably?
Your Honor, if creditors will also be able to consult with each other well ahead of the meeting. So just following the timeline which we had enclosed, unfortunately, this is enclosed to the convening submissions, Your Honor.
Mm-hmm.
At the very last page, we were directed to enclose the expected timetable.
Mm-hmm.
The latest version has the proof of debt submission deadline.
Mm-hmm.
If Your Honor is with me, it's the very last page of the convening submissions.
Yes.
OA 881.
Yes.
Your Honor should see an expected timetable of principal events.
Mm-hmm.
Your Honor would see 5 rows from the top. Proof of debt submission deadline is scheduled for 28th September. Your Honor, within 7 days after that, the chairman is supposed to publish the full list of creditors.
Mm-hmm.
So that brings us to essentially the first week of October. Then, if you see on this timetable, the scheme meeting itself, if Your Honor can see it, it is the date. It is entry dated 28th November.
Mm-hmm.
So creditors will have just about 7 weeks, by my estimation,
Mm-hmm.
to consult with each other well ahead of the scheme meeting, Your Honor.
All right. So on your approach, what will be the date as per this table when the sealing will not be in effect, so to speak?
By 5th October.
5th October.
Yep. That is, I'm just taking 7 days after proof of debt submission deadline.
7 days after. All right.
Yep.
All right. All right, carry on, please.
Just to pause here to note that if judgment is reserved by a couple of weeks, all the timelines will be pushed back by 2 weeks. But the amount of time, the 7-week timeline for creditors to consult with each other even before the scheme meeting would still apply. Your Honor, those were my submissions on sealing. There were certain objections raised as to class, basically saying that the sealing prevents creditors from being able to identify what class they are in.
Mm-hmm.
Your Honor, I think the fundamental point here is that creditors have been provided sufficient information about class and are able to identify for themselves whether they fall within the one class of unsecured creditors, which the applicants have proposed in this case.
Mm-hmm.
If creditors had truly been unable to make arguments about class, then Parastate wouldn't be able to make the exact arguments which they are making, which is that they are not part of the same class and that they should be classed differently. Your Honor, that is the short response. The longer response is something which we had addressed extensively in a letter filed in response to Providence law, which acts for derived. I'll just give Your Honor the point site. This is in the 8th affidavit of Yang Zhou. At page 26. And I will just very quickly take Your Honor through the points which are raised all at page 26, which
What
is first of all
this affidavit, please.
8th affidavit of Yang Zhou.
What date?
Oh, sorry, 18 September.
Hold on, please.
Thank you.
All right. Yes.
At page 26, at paragraph 7, we deal with precisely this question of whether the objections to the sealing application have any relevance to class. First of all, we submit no for 4 reasons. First of all, creditors have already been provided with full details of the nature of creditor claims arising from the 3 different lines of business of the debtors. We specifically identified in numerous paragraphs all the way, in fact, we identified this at the first moratorium extension affidavit in March 2023, where there were 3 main lines of business of the debtors, which was firstly, cryptocurrency lending, second, cryptocurrency trading, and third, asset management. And we set out exactly what each of those business lines entailed. Second, Your Honor, we had even provided the typical and template agreements which the debtors have entered into with numerous creditors. We only set out two examples here of master loans agreements and cryptocurrency management agreements. But rest assured, Your Honor, that the first affidavit contains, if I'm not wrong, 7 different contracts, and Parastate has exhibited their own, bringing the total to 8. Your Honor, I will skip down to paragraph 8, only because I've covered the rest of the points already in paragraph 7. At paragraph 8, we point out that all that is sought to be sealed are the names, signatures, and contact information. The real question which we have is, how does the name of the creditor disclose any information about class? Instead, the real focus should be on the nature of the debts, not really the name, which we have described already and even provided template agreements. Your Honor, we had also provided at paragraph 9, I'm now on page 27. We had also provided, first of all, a relevant alternative report, sometimes referred to as a liquidation comparator. And we expressly set out the conclusion in the relevant alternative report that debtors of each entity will receive, all 5 entities, will receive recoveries of 0% in the low case and recoveries of between 0 to 2.2% in a high case. And we explain that that is the reason why we take the view that it is one class of creditors. Next, Your Honor, even if you don't accept the relevant alternative report provided by Houlihan Lokey, the independent advisor, sorry, there's a typo here, it should be advisor, not assessor. FTI.
Mr. Yo, I think we need to move along a bit more quickly, because this is just the ceiling point.
Agreed, Your Honor. I think then I will confine my response just to this one last point, which is that the independent advisor has opined that it would be appropriate to convene a single class because creditors seem to have similar rights.
All right, thank you. All right, let me turn then to Mr. Chu for Parastate. You're objecting to the sealing?
Yes, Your Honor. If I may just make I suppose, two main points in response to my learned friend's arguments. I think, Your Honor, first of all, the concerns that creditors have, my client, as well as I think those creditors who are represented, is that we are not at the stage of moratorium now. We are at the stage of leave convening. For the last 6 months, it's been a case of dividing and conquer. Unless creditors actually appoint solicitors, we don't actually know who the creditors are. We can't actually discuss with them. And I think my learned friend is right when he says that if Your Honor grants the leave application to convene the scheme meeting, then it is time for creditors to actually be allowed to consult with each other. And if that is the case, Your Honor, if the sealing order is actually, if the convening order is actually granted, then there's really no need for this sealing application order to be granted at all. So that's my first response, Your Honor. My second response really is this. My learned friend says the customer list and all its creditors list are actually its assets, which potentially, if disclosed, would then lead to a situation where they might lose their competitive advantage. I think, Your Honor, we cut through the chase and we will know that Babel is now hopelessly insolvent. The scheme that Babel is actually proposing is not a continuation of his old business. So to that extent, my learned friend says these customer lists and this creditor list, if disclosed, will essentially mean that they give up their competitive advantage. I would say that's quite irrelevant when Babel doesn't even want to carry on his old business. So ultimately, at the end of the day, I think my learned friend makes the concession when Your Honor asks, so when will the ceiling actually be lifted? My learned friend's answer was by 5th October or, subsequently soon afterwards, so that creditors have 7 weeks to consult with each other. I think, Your Honor, that in itself underscores why this application should be dismissed. If Your Honor grants the convening application, the sealing order is not required. 7 weeks to consult with each other, on the face of it, Your Honor, might look like a long time. We don't know what kind of information will be given when it comes to the release of the creditors list, because this, Your Honor, is a restructuring on the international scale. We have to consult with other creditors. We have to contact the creditors. If all we have is the name of the creditor without actually their contact details, Your Honor, effectively, like what Your Honor says, will end up only being shepherded into the scheme meeting without the ability to consult with each other at the beginning, prior to the meeting. So those, Your Honor, effectively are my 2 points why the sealing application should be dismissed, especially if Your Honor grants the convening application.
Thank you.
That's all I have, Your Honor.
All right, thank you. Before I turn back to Mr. Yeo, anyone else present wishes to be heard? Any of the other counsel wishes to be heard on sealing? I think not. If that's the case, back to you, Mr. Yeo.
Thank you, Your Honor. I will address the 2 points in order. Firstly, Your Honor, my learned friend says that there's no loss of competitive advantage because the Babel Group is pivoting to a new business line. Your Honor, that's not entirely accurate, as the affidavits have set out very extensively. While the Babel Group is going to include a new business line in the go-forward business, that is the DeFi business, the decentralized finance business, the traditional CeFi business is still a business line which will be continuing, albeit not with the same focus as before. So that's just a simple factual correction which I think needs to be made, which I think addresses one of the 2 points already. The second, Your Honor, is in terms of timing. My learned friend says that there's no point to the sealing submissions once the convening order is made. But as Your Honor pointed out, and as we anticipated, it will take at least a couple of weeks for a decision on the convening order to be made. The question is, should the unredacted letters of support all be essentially out in the open now, as opposed to hopefully 2 weeks from now when the convening order is made, or where the list of creditors comes out a couple of weeks after that. So the issue is one of timing. I don't think the rebuttal from Parastate really deals with the fundamental issue of should creditors who have provided letters of support be identified today, because the sealing application is intended to be determined today.
That is all then, Mr. Yeo.
Yes, thank you.
All right, let me have a minute. All right, thank you. I will note that the granting of sealing is not made lightly. Transparency is to be preferred, but the court has recognized in the various cases here and abroad the need to facilitate commercial confidentiality in order to advance restructuring. And that is simply part of commercial reality. Here, I do accept that the sealing is limited in duration and purpose. What is the concern is whether thereafter the creditors have sufficient time to at least prepare for consultation. I will therefore grant the sealing, but I may modify its duration or lifting once I determine whether the convening application should be granted. So matters here are sealed, but its duration and how it interacts with the convening application and schedule, I will determine once I give the decision on convening. So that's my decision at this time. Let us proceed then to the arguments on the convening application. Mr. Yeo, back to you.
Thank you, Your Honor. Very quickly, Your Honor would have a set of written submissions in OA881.
Yes.
I believe I took Your Honor to it just now, but Your Honor, I think I will follow this quite closely. I do not intend to take Your Honor through every point, but confine myself to the major ones. Your Honor, starting at paragraph 5, just a quick refresher on the timeline. We first applied for moratorium protection on the 6th of March 2023. Thereafter, I think 2 rounds of moratorium orders or extension orders were granted on 17 April and 3rd July. We then worked on inviting feedback from creditors and made extensive efforts to make presentations, send follow-up emails, address queries, and so forth. And we are now at a stage where we have finalized key documents for the proposed scheme. I realize there's quite a lot of material for creditors. The explanatory statement, if I'm not wrong, is 590 plus pages. And the scheme itself is 40 plus pages. Um, uh, During the course of inviting feedback from creditors on the updated restructuring term sheet and restructuring plan, we actually received no feedback at all from any creditor, no substantive feedback on the updated restructuring term sheet, including from any creditors who have either supported or objected at today's hearing or otherwise. Paragraph 11 is important, and I intend to take your honor through that. It is to summarize the key terms of the proposed scheme.
Mhm.
First of all, as will be probably dealt with later on in detail, the proposed scheme involves a deed poll structure that combines the claims of against all the debtors into a single scheme. This deed poll has been executed by Babel Holdings Limited, that is the applicant before your honor today,
Mhm.
To assume the liabilities of the other debtors, which is Babel Asia Asset Management, Babel Block, Moon Alpha, and Shina,
Mhm.
in respect of the liabilities owed by all of them. Following the deed poll, the company therefore proposes a single scheme arrangement with all scheme creditors to compromise all scheme claims owed by all 5 debtors.
Mhm.
And as for the scheme itself, the scheme proposes to release the debtors from all scheme claims in exchange for scheme creditors receiving one of 2 forms of scheme consideration, which they have the right to elect between. The first is ERC20 compliant tokens called Babel Recovery Coin to be issued by a new entity, that is the BRC issuer.
Mhm.
And secondly, the creditors can instead elect to receive contingent value rights or subscribe for contingent value rights to be issued by new holdco. So broad approximation, this is almost like equity.
Sorry, it is almost like
Equity.
Oh, sorry. All right. Thank you.
If creditors do not elect, then the default scheme consideration will be the Babel Recovery Coin. Now, what the Babel Recovery Coin holding represents is the right to redeem a pro rata share of a sinking fund. Contributions to the sinking fund are supposed to come from, first of all, disposal proceeds of various private equity investments of the entire group. Secondly, a percentage of the net profit of the new holdco.
Mhm.
Essentially from the new business model, from the new business to be conducted. And third, this is a new addition. Any potential recoveries of the debtors from potential litigation proceedings against Del Wang or Wang Li, including in connection with proprietary trading activities. Your Honor will recall at the previous moratorium extension applications that it had actually been proposed that there would be third-party releases against all officers and directors, including Mr. Wang Li. However, at the sacrifice of some contribution from Mr. Wang Li, he has now been excluded from any third-party releases to be granted under the scheme. Your Honor, I will be describing the third-party releases in further detail, but essentially, because the scheme company is going to be Babel Holdings, there will be third-party releases in favor of the other debtors, the other 4 Babel entities that had originally applied for moratorium protection. And there will be, and this should be highlighted for everybody's benefit, that there will be a third-party release in favor of Mr. Yang Zhou. He is the deponent to almost all of the affidavits on behalf of the Babel Group. And the rationale for his third-party release is that he is contributing significant assets and investment towards the new business of the group, which is at least 13.8 million, but could go up to 20 million depending if any other existing investor drops out. Basically, he is backstopping any investment in the group.
Mhm.
The other rationale is, of course, that Mr. Yang Zhou was not actually involved in the company at the time of the proprietary trading activities, which caused significant loss anyway.
Mhm.
So as a result of that, there is a draft report by the group's independent advisors, that is FTI, which expressly analyzed the fairness of the proposed release in favor of Mr. Yang Zhou and concluded that it is not unfair or unreasonable.
Mhm.
So bottom line, Your Honor, within just 5.5 months of the first moratorium orders, the group is now ready to put its full form scheme to the group's creditors. Your Honor, paragraph 14 onwards deals with the applicable legal principles at this leave to convene scheme meeting stage.
Mhm.
Your Honor, essentially, the courts do not consider the merits or reasonableness of the scheme. That those are issues for creditors to decide at the first instance before the court considers the same at the sanction stage. Instead, the analysis at this stage focuses on the fairness of the context in which the scheme is to be presented to creditors and on issues concerning the court's jurisdiction to sanction the scheme later if it proceeds. Leave will generally be granted if, at paragraph 16 of my submissions, the classes of creditors are fairly constituted. So I do need to satisfy Your Honor on that. Second, that there's a realistic prospect of the proposed scheme receiving the requisite approval of the creditors. And third, that there's no abuse of process.
Mhm.
There is also a duty to unreservedly disclose all material information to the court. Your Honor would have seen from the affidavits which we have filed, we quite simply have disclosed numerous things which are probably harmful to getting relief. We were the ones who disclosed that there was proprietary trading which had caused significant loss. We have also been forthright to disclose numerous other aspects which I will go into later. Your Honor, I will skip then to paragraph 20. Paragraph 20. This is on page 8.
Mhm.
Essentially, this deals with jurisdiction. I hope this is not disputed. I have not seen any dispute on this in the submissions filed by any party. That the applicant is a company which has the requisite standing. It is a foreign entity. However, in granting the moratorium orders on the 17th of April, the Honorable Court had already been satisfied at that stage that the foreign debtors, which include the applicant, have a substantial connection to Singapore and are liable to be wound up. Among other things, just to very simply recap just one or two of the connecting factors, I think the easiest one is that Babel Holdings own shares in Singapore subsidiaries here in Singapore. And substantial business was carried out of Singapore. We were, albeit belatedly in February, registered to carry on business in Singapore. Your Honor, I will turn now to the disclosure of sufficient information. That's at paragraph 25, unless Your Honor has further questions on jurisdiction. At paragraph 25, we have provided detailed information to the court to assess the feasibility of the schemes and whether it merits consideration. First of all, we provided at Annex A to the convening application an advanced draft of the scheme. Secondly, we provided at Annex B to the originating application the explanatory statement. As I said, this is nearly 600 pages, which contain detailed disclosures of various matters. Third, we provided the rationale for the scheme. And most important to that is the creditor recoveries in the relevant alternative report or liquidation comparator, Your Honor. Fourth, Your Honor, over the page, we had provided the unaudited management accounts of the group. We had fairly disclosed to all creditors and the court that we are unable to identify which entity owns what asset for quite a few of the group's assets. Because the assets of the group, I think the term used by Parastate had been commingled. So we had disclosed this upfront, all the way back in our very first application in March. And therefore, the standalone accounts have been prepared on the basis that the pooled assets of the entire group are shared pro rata amongst the debtors, pro rata in accordance with the net external liabilities of each debtor. Fifth, we had also provided the independent advisors analysis as well. To essentially confirm or rebut the conclusions reached by the financial advisor. Your Honor, at paragraph 30, I just wanted to highlight some of the important facts and factors which have been disclosed. First of all, that there will be third-party releases in relation to, originally it was in relation to all directors and former directors, but that had since been narrowed to a third-party release in favor of the debtors themselves and Mr. Yang Zhou. And an independent assessment of those third-party releases was sought from FTI, the independent advisor. Second, Your Honor, we had expressly disclosed that the assets of the group are so intertwined that it would take vast expenditure and time, neither of which can be afforded, to identify which entity in the group owns the remaining cash and crypto held in wallets and accounts. Third, Your Honor, we had provided continuous updates to creditors on the new money investment plan. Just to flag the point here that originally the court was provided a figure of, I believe, $47 or $48 million as the target for new money, of which 20 million would essentially be new money term sheets or new money investment as opposed to warrants or CVRs. Since that time, the total amount of new money has declined to 39 million, and that reflects the transition between term sheets, mere term sheets, and actual long-form documentation. So essentially, we had a little bit of dropout along the way. So we expressly disclosed this to all creditors and the court on a very timely basis in letters to court and then later on in affidavits. There was also a decline in contributions from Mr. Wang Li, which is directly connected with his with him not being provided a third-party release. So we had received an initial contribution worth approximately US 2 million in the form of assets. But beyond that, I would not expect further contribution unless things change in relation to his third-party releases. We also provided express updates to the court that Babel Asia Asset Management's lease of office premises in Singapore had been terminated. So that unfortunately shut down one of the offices in Singapore. And we also provided express disclosures in relation to the group's interest in shares of a company called Cypher, or an investment called Cypher. Essentially, there's a footnote reference to where we describe this in about 18 paragraphs or so. But the short summary of it is that the group has received allegations that the group has no further interest in Cypher, and that this interest had been disposed of in agreements signed by Mr. Wang Li. And we had provided the relevant agreements which appear to have been signed. So, Your Honor, while that private equity investment in Cypher had been listed as a potential asset in the first moratorium affidavit, at the beginning of this process, it does appear that at the very least, ownership of that private equity investment is now disputed. Your Honor, we had also highlighted numerous other issues in relation to how the scheme will take place and work. That is dealt with more fully in the financial advisor's relevant alternative report and in the independent advisor's FTI's draft IA report. Just to flag one of those points on paragraph 31, subpara 5, we specifically highlighted that there's an uncertain regulatory position in relation to the Babel recovery coins and CVRs, as well as the risk of having no parallel schemes or ancillary restructuring proceedings in other jurisdictions. The company takes the view that while the independent advisor has highlighted this, and we have duly highlighted it to creditors as well, there is no need for a parallel scheme in another jurisdiction for now. We have also very promptly provided full updates to all creditors anytime we receive a letter indicating opposition. In particular, once Parastate indicated that they would be opposing and filed affidavits to that, affidavits and submissions to that effect, we had duly provided that to all creditors. We had also provided updates to all creditors of 2 other oppositions which we had received via letter promptly. Your Honor, I will then turn to the issue of disclosure at paragraph 33. This relates specifically to Parastate's allegations that there's a lack of disclosure. Yeah, Your Honor, I'll just deal with this very briefly because the reality is we've actually provided all this information. First, Parastate alleges that there's been little or no explanation as to how the debtors became insolvent. We respectfully disagree. We described this in 23 paragraphs in the very first affidavit filed in March 2023. And to very broadly summarize this, there were 3 or 4 factors which went to the insolvency. First, the catastrophic crash in crypto that occurred after Terra Luna. Second, the proprietary trading activities, which had been led by Mr. Wang Li. We ourselves expressly described what those proprietary trading activities were and why they were risky. Third, combined with the crypto crash, that led the proprietary trading activities obviously caused massive loss, and we identified exactly how much loss was attributed to that. Third, Derived had then proceeded to set off several different sub-accounts against each other. There are proceedings in the Dutch court in relation to, among other things, Derived's claim against Babel, but also our issues against Derived, where we say that there had been certain no set-off agreements or non-liquidation agreements where Derived was not supposed to have set off different sub-accounts against each other, but was supposed to have maintained each sub-account as a standalone. That is a disputed issue. I do not intend to commit this court or myself to either position, but just simply to flag that that is a disputed issue, but also a cause of the current insolvency. And fourth, we also highlighted the numerous margin calls which we received following the crypto crash, which led to essentially several accounts with different trading partners being liquidated. Your Honor, there's other allegations. We have provided point citations to where we have responded to and explained each of these issues. Your Honor, dealing now with the issue of class at paragraph 35, Your Honor is even more familiar than I of the dissimilarity principle, which is the test for fairness of classification of creditors, and with the 3-step inquiry, which was identified by the Court of Appeal in Pathfinder. So I do not intend to go through the legal test. Instead, I will go straight to the arguments on class at paragraph 38. At paragraph 38, subparagraph 1, we say the creditor's rights are not so dissimilar. They can and should be put into a single class because each debtor's likely alternative to this scheme is insolvent liquidation. I believe that is accepted and advocated, in fact, by derived and Parastate. Based on the financial advisor's analysis of creditor returns in the relevant alternative report, creditors will receive a return of either nil across all 5 entities in a low case, or between 0% and 2.2% in a high case. Given the similarity in range of recoveries, it is fair and justified to compromise scheme claims against different debtors in the same scheme and in the same class. Second, Your Honor, notwithstanding that the original denomination of scheme claims were denominated in different digital assets, so some were Bitcoin, some were USDC, some were Ethereum, and so on. We have proposed to scheme each of these different digital assets in the same class, just simply using the same fiat currency, US dollars, and a common scheme conversion rate, which takes into account value fluctuations during the period since we announced suspension of withdrawals. So, Your Honor, the group announced suspension of withdrawals, I believe, in June 2022. So the conversion rate, the scheme conversion rate, proposes a volume-weighted average price approach, which essentially takes a weighted average of the price of each of these different digital asset prices from June 2022 to date. Third, Your Honor, certain debtors had provided collateral. However, the terms of that collateral doesn't really suggest that there's any retention of proprietary interest. So we have submitted that these appear to be unsecured claims. But even if they're secured claims, Your Honor, that the reality is what we are scheming is effectively the net claim. The scheme provides for the collateral to be set off, and for the balance claim, which is the unsecured portion, effectively, Your Honor, to be what is schemed. So, Your Honor, I don't believe there should be any controversy as to debtors who have provided digital assets as collateral to some scheme creditors, resulting in a fracturing of class. Your Honor, the point I would highlight is subparagraph 5 on page 17. And this is something we had again very transparently highlighted to creditors, which is that there have been payments which were made by the debtors. It is relatively small in number, but there were payments which were made after the debtors announced the suspension of withdrawals in June 2022. Now, there were a couple of ways of dealing with these post-payments, as I intend to refer to them as. Either we could have ignored it entirely in the proposed scheme framework, or we could have tried to take it into account somehow. The way that the scheme tries to take it into account, so we have opted for that option, is to deduct from the scheme claims the amount of the post payment. So if a scheme claim is $10 and the post payment was $3, then the 10 minus 3, the admitted amount will be $7. And we have empowered the scheme manager to make that assessment following certain criteria, which essentially will mirror like an insolvency clawback, or not the full insolvency clawback, but just the assessment of whether there was a desire to prefer. Your Honor, there is also the relevant not just the relevant alternative report, but also the independent advisors report or draft report, which essentially identifies, Your Honor, this is at paragraph 39, which essentially identifies that creditors would appear to have similar, if not identical, rights, and therefore it would be appropriate for them to be consolidated into the same class. However, they do highlight a specific point, which is, had each scheme company proposed separate schemes, there are 4 creditors who would have had a blocking vote if there was no consolidation of the debtors' liabilities. However, Your Honor, if Your Honor is persuaded by our submissions on substantive consolidation, the deed poll structure and or pooling, as reasons why there cannot be separate schemes, because we simply
All right,
can't.
Theo, I think you know where Parastate's primary objections are going to be. So we're coming up to 11:20. So I think we really need to move on to the main point.
I understand, Your Honor. The main point that Parastate makes is essentially that they have a trust.
Yes.
That puts them into a separate class as secured creditor. Your Honor, I will raise a couple of points about that first, and then I will turn my time to Mr. Andrew Chan to hopefully take it forward.
I really need all of you to please move quickly, please, Mr. Yo, Mr. Chan. Focus on the main points. I've read through your submissions. You really need to just please focus on. I have another hearing in the afternoon. We're not going to spill over. I need to give time to Parastate to respond. It is 11:20. You have 15 minutes to complete your arguments. Please proceed, Mr. Yo or Mr. Chan.
I understand, Your Honor. Very quickly, this is at page 27 of my submissions.
Yes.
Your Honor, I will not belabor most of this, but essentially the point is that Parastate has not commenced any arbitration proceedings in respect of their claims, despite having commenced proceedings in court and then having that stayed on the 22nd of November. There was no moratorium until the 6th of March, and even then there had been no claim made. Let's turn now, Your Honor, to Mr. Chan, who will address you on the issue of the trust.
Yes, thank you. Mr. Chan, within 15 minutes or less, please.
Yes, Your Honor. So, Your Honor, page 18 of our submissions.
Yes. All right.
So essentially, I will need to address several points. One, whether there was a trust. Two, even if there was a trust, part of our case essentially is there are no trust assets anyway, so it doesn't matter because the claim is actually an unsecured claim, a claim for equitable compensation. And then I have to deal also the point about consolidation and the points about deed poll. Those are the objections, and I will deal directly with them. So the 3 responses, para 41, we say no trust. Even if the trust, any claims are unsecured. Number 3, we say essentially, there's a third point which is not raised by Parastate itself, but I will deal with the point very quickly in our submissions, only because we have the duty of unreserved disclosure and the duty to bring to the court every point which might affect jurisdiction. So that's a point which is not raised by anyone, but we'll deal with that very quickly.
No, you can the submissions really, Mr. Chan, please.
The Singapore courts have accepted that cryptocurrency
Mr. Chan, can you hear me?
held on trust. No
Mr.
question.
Chan, can you hear me?
The question is then whether there is on the facts of the case a trust. Paragraphs and
Mr. Chan, can you hear me?
Mr. Chan.
sorry, what is it?
Is your audio on? Unmute.
What is it? It is unmuted. It's unmuted.
Mr. Chan, I was trying to speak to you. Please just focus on the main points of trust and all that. The other points in your arguments, scatter arguments, just leave it there. Sorry, I really do not have time to give you full leeway this morning. I have another matter in the afternoon. We need to finish by 1. All right. So please just focus on the trust arguments. At this point, I want you to finish by 11:40. All right. Please proceed.
Can you only hear me?
Yes, I can hear you. I don't know whether you can hear me.
Yes.
Annie, can you hear me?
Okay, yes, Your
Hold
Honor.
on, hold on. Can you hear me, Mr.
Yes, I can hear you.
Is your volume
Mr. Chan, can you tell me you can hear me?
Okay.
Oh, gosh.
Yeah, sorry, Your Honor. I had some
Mr.
difficulty.
Chan, Mr. Yo, can someone on the ANG side hear me?
Yes,
Yes.
yes.
Your Honor.
All right, please. Mr. Chan, 11:45, just focus on the main points on the trust issue. Just address what Parastate is arguing. All right, please proceed.
Yes, Your Honor. Case law, paragraphs 44, 45 essentially sets out the requirements for trust. And one of the points essentially is there identifiable trust property, or is this something which what was reflected in Parastate's, if you like, wallet is not necessarily reflected in terms of how it's actually dealt with, meaning the cryptocurrencies were dealt on a collective basis. They just have a right of withdrawal, hence consistent with an unsecured obligation. That's what paragraphs 44 and 45 essentially draw in terms of the distinction. And on the facts itself, Your Honor, we suggest that there is paragraph 46, no express provision imposing a trust or any fiduciary duties. At 46, Your Honor, what was quite important in the decision in New Zealand, Roscoe, was the fact that there was an agency clause. I think that I will deal for and on behalf of the, that means in this case, I suppose the Babel entities will deal for and on behalf of the, if you like, the depositor. There is no such clause in our particular case. In fact, the clause says, unless it's expressly provided, I'm not an agent. And 2.3 says, for me to be an agent, what actually happens is I need separate documentation. There is no separate documentation here. The net effect of which is that when Babel Asia, in this case, actually they deal as principals. They deal with and they invest it as principal. It's not in the capacity of on behalf or as an agency. Hence, consistent effect, there's no trust. The other points also is that they were never segregated. Why? Paragraph 47, no express requirement. 2, it's like structured deposit. You withdraw, you put it in. Now, paragraph 47.3, Your Honor, we have set it out in the affidavit itself, which this paragraph refers to. They seek many benefits. One of those benefits essentially is I have a right to withdraw. But if your assets are actually segregated, you're supposed to invest and you can withdraw early. I'm going to have difficulty withdrawing because that's going to put me in breach of contracts or what have you. In other words, they want you to manage, they want you to get a maximized value, but at the same time, it's segregated, not to be mixed together. The point which is made in affidavit essentially is that that's not how we actually operate when we manage. We manage because we have the ability to actually deal with it as a whole, the ability to actually match different maturities and whatever, maximize value. Otherwise, if a segregation is simply does not work, the net effect of which we are essentially saying is that no, as far as this is concerned, the simple position is that there was no trust. Trusts are not to be imposed lightly. Paragraphs 48, Your Honor, the point which we make here essentially is this. End of the day, there is no trust assets. The analysis insofar as Babel Asia is concerned, Your Honor, and Babel Asia is what we are concerned about because Babel Asia is the entity which Parastate dealt with. Smarty, one of the other objecting creditors as well, they also deal with Babel Asia. The derived deals with Moon Alpha. Babel Asia, Your Honor, high recovery, low recovery, no assets. But paragraph 50, Your Honor, the point is really this: if you say they're assets, or you say they're assets subject to the trust, paragraph 50 says basically Babel Asia has no cryptocurrency assets left. So what's your claim? Therefore, is a claim for essentially whatever view one takes in relation to the trust. We say there's no trust. That essentially is now a claim for equitable compensation. Equitable compensation is a personal claim. That is a claim which means that, I mean, you can call it different, you can call it tort, you can call it contract and what have you, but the reality is this: no assets, therefore, they simply stand equally. There's no proprietary claim. That's the end of the matter. So that in itself, Your Honor, is enough to actually determine the point whether or not there was actually a trust. Paragraph 53, Your Honor, this is our duty as counsel because we need to highlight the court every point which might affect jurisdiction. Paragraph 54, Your Honor, essentially is this. In the Lehman Brothers Europe case, Lehman Brothers Europe case was essentially concerned with the situation in which the court was confronted the situation in the Lehman collapse. How to distribute the trust assets among the various claimants. That was simply a case of distribution of trust assets. And they tried to use a scheme methodology or the scheme jurisdiction. The Court of Appeal there basically says you can't because in reality, this is a purely proprietary claim. Now, we say that perhaps Lehman should not be followed in Singapore, but doesn't matter. Lehman can be restricted to specs where it's simply a proprietary claim or pure proprietary claim. Our claim, in this case, because there are no trust assets, is one of equitable compensation. And in that particular sense, we say it doesn't really matter. Lehman does not stand in our way, or the facts are different. And applying on our particular facts, Your Honor, paragraphs 58 to 60 onwards, 60 in particular, this is not a mere proprietary claim or pure proprietary claim. But even if it is, Your Honor, we say that in this particular case, we got three further submissions. Our first point essentially is that this is not a proprietary claim. It's an equitable compensation, therefore no different class. Paragraph 60 essentially is, so long as, even if it's a proprietary claim, if I'm a creditor, why should I be precluded from being a creditor? In other words, we may perhaps follow the Australian position as opposed to English position. Number two, Your Honor, at paragraph 62, there is some writings by Geoff, etc., and this in footnote 107, essentially making the point that where your claim is predominantly that of a creditor, in this case, it's equitable compensation, zero assets, or even if you want to claim, maybe there's some assets, minimal assets. The views which the authors take essentially is, why should the scheme jurisdiction not actually be available? And this, they say, gives effect to the legislation better. And in Singapore, we all know when we construe provisions of statute, we take a purposive interpretation, in which case, perhaps we should depart from England, we should follow Australia, but no need to decide if the court accepts that this is not a purely proprietary claim. Number three, Your Honor, again, in Pathfinder, the court accepted the test is, where is the closely related claim against a third party? This is third party releases, sufficient nexus. The court accepted sufficient nexus case, actually agreeing with Your Honor's decision in Pathfinder itself. If the question, if I can release a third party, what is a right against a third party? A right against a third party is a right which a creditor may have. It's a property claim. Why should some forms of property, because it's a claim, and other forms of property cannot be released? What is the point of distinction? So perhaps if it was necessary for us to depart from England, our proposition essentially is we should, but it does not matter because in this case, it's not a proprietary claim. So we highlight this because it's part of duties. No creditors raised this. And the bottom line of all of this is that we have scheme jurisdiction, proposition number one. Proposition number two essentially is, Your Honor, that the proposition is that this is an unsecured claim. Why should we not be classed together? And therefore no separate particular class itself. The other points, Your Honor, which I can skip because I want to move straight to the proposition in relation to the deed poll, and that's at paragraph 70, because that's, I think, the other point which what is parastate and derived, and to some extent also adopted by Smarty. Essentially, Your Honor, the deed poll structure and this point about substantive consolidation, they are interrelated. Paragraph 71, Your Honor will recall in DSG, three particular factors come into play when looking into the deed poll structure. Number one, whether it unfairly overrides their rights. Number two, is it artificial? Number three, is there some other alternative, right? So those are the 3 points. So that's in terms of the law. They've only taken the point in terms of what do you call it? They are basically saying it's not appropriate, it's a whitewash, it's overrides the rights. But the point in terms of overriding the rights essentially starts from the proposition. If your claim essentially is that of unsecured creditor, then that's the whole point about the scheme. There's no overriding. That's the position we should start with. So let's look at the reasons itself why we say it's actually appropriate to have one class of creditors and therefore the deed poll. Number one, Your Honor, paragraph 74, it may be proposed on the basis that the groups and assets and liabilities in this case are pooled together. Your Honor, let's look at the alternative for a moment. What is the alternative? The alternative is 5 schemes. Number one, I got to determine which assets, which liabilities. Number two, even if I can somehow spend a lot of money and trouble, there are issues. How do I allocate? What rules do I apply to decide assets? What prevents one creditor from saying, look, since all of this is intertwined, I'm filing my claims in 5 different schemes. You have a different set of problems there. It becomes a very complicated, unnecessary scheme. In liquidation, the courts have said you can essentially view them and pool them together. Why not a scheme where, in comparison, the most likely comparator, you do what is the most logical and what is the best way to actually do this? So, Your Honor, therefore, in 74.2, bear in mind that assets and liabilities, the alternative is difficult, creates more difficulties, raises all new kinds of issues of jurisdiction, etc. It's in those senses that substantive consolidation makes sense. 74.2 deed polls make sense. And also, Your Honor, in 74.3, this is really how it is actually dealt with in a liquidation. That's the comparator. In other words, if in liquidation this could be done, why not propose a scheme which mirrors essentially what follows most closely or most logical in liquidation? I mean, the alternative would incur your costs, I have difficulties, I know I'm a secure claim, I know there are no assets, but I'm going to make life difficult for you. Your Honor, that's not how the scheme jurisdiction should actually work. In fact, this is the kind of case where really, in reality, this is the most logical way to deal with it. I mean, whatever wrongdoings, if at all, one can take a view, one can take different views, have been disclosed. It's not a question of non-disclosure. So what we essentially are doing is this. Not only have we do something which actually makes sense, and and it's been accepted by Your Honor, paragraph 75, the depot structure substantive consolidation per se is not wrong. In which case, Your Honor, this is actually the most logical methodology. The alternative has own other issues. We outlined some of these particular issues in 76, was time and difficulties, and then we also talk about paragraph 78, for substantive consolidation. We set out our reasons there. Essentially, there's no trust assets. Really, we are looking in terms of, if like one dealing as the companies as a whole. It is really the alternative para 80 or entity to entity level schemes is crazy. What prevents one creditor to file 5 different claims? How am I going to ascertain? I don't even know the assets, whether here or there. It creates all unnecessary difficulties. So much simpler when in liquidation, at the heart of the matter is this, that essentially we're going to pull all of them together. Why not do so likewise? Your Honor, I have 3 minutes left in terms of my timing, and therefore, I'll move on. And so when you look at the range of recoveries, and the point is really this, at the heart of the matter is this, these are just mechanisms. If the scheme jurisdiction is available, let's look at the benefits. Significant monies have come in. The advisors' reports have come in to say this is actually beneficial. And the reality is this, now therefore, should the scheme jurisdiction therefore be available to enable something which is a benefit, the merits of which is to be determined at a later stage. So the point essentially at paragraph 82 as well is that it's feasible on the ordinary principles of commingled funds. I already made a point. Commingled funds, the alternative is liquidation, consolidated. Why should the scheme not follow something likewise, Your Honor? So how is this overriding the rights to begin with when at the end of the day, they start as unsecured creditor? How is this artificial when in reality, this is the most logical method to actually proceed? In terms of alternatives, what are the alternatives? It's all a set of problems. If we took the alternative, they would take all kinds of objections. At the heart of the matter is this. This is a scheme, much time is spent, much money is come forward. In 5.5 months, we propose something which is serious. Your Honor, our submission is that these are matters we should go to for the creditors to decide at the scheme level. Your Honor, I've kept my time exactly.
All right, thank you, Mr. Chan. Mr. Yeo, anything else before I turn to the Pearl State?
Your Honor, nothing else.
All right, thank you. All right, Mr. Chu.
Yes, Your Honor, if I may, Your Honor.
Yes, it could take about half an hour, 40 minutes at the most. Thank you.
Yes, Your Honor, I hope to finish within that. In fact, I will. Your Honor, for the record, we oppose the convening application. I have 5 main points to make, Your Honor. Your Honor, the first point is that we say that the applicant has not made sufficient financial information available for us to determine that there will be a fair conduct of a scheme meeting. My first point, Your Honor, really is that there has been not a single historical financial data disclosed by the applicants and the companies to date. And I say this is important for a few reasons. First sub-reason, Your Honor, at explanatory statement page 32 at para 1.09, we know, Your Honor, Babel had raised a total of 125 million from 8th of January 2021 to 25th of May 2022. In fact, Your Honor, the last fundraise was done 1 month before Babel collapsed.
Mhm.
And that amount is 80 million US dollars. No one, Your Honor, to date, not the companies and not the expensively assembled team of consultants, have sought to explain or investigate where this monies went.
Mm.
And I would say, Your Honor, as part of the fundraising, surely there must have been financial information prepared and made available to the investors.
Mhm.
Babel has not produced them at all. That's my first sub-point, Your Honor.
Mhm.
My second sub-point is when one looks at the reconstructed balance sheet, and I say reconstructed because it was actually done out by Houlihan Lokey. They prepared the data only for the period of 1st January 2023 and 30th June 2023, way after the collapse of the Babel Group. And what do they give you? They give you a balance sheet that shows you that they are hopelessly insolvent. They show you what their liabilities are. The information there is sparse and doesn't amount to any meaningful disclosure at all.
Mhm.
So I would say, Your Honor, we are now being pressed as creditors into a position where we effectively have to accept a fait accompli. You either accept this situation as it is, or you get nothing at all. But, Your Honor, my point really is this. It doesn't necessarily have to be the case.
Mhm.
We have asked Babel specifically whether there have been any sums of monies that have been taken away by the controllers of the company. The answer we got, Your Honor, and this is at paragraph 59 of Yang Zhou's third affidavit, is that nobody took money from the company after June 2022, except for salaries. I say that's deliberately being opaque, Your Honor, because June 2022, they are insolvent, they crashed. So obviously there's nothing for them to take after June 2022.
Mhm.
And I'm raising this, Your Honor, because this is a potential area for clawback in a liquidation scenario. There must have been information that is material to creditors for us to determine as between a liquidation scenario and a scheme, which is better. For example, if funds have been taken out for no justifiable reasons by the controllers, then potentially in a liquidation, there might be claims for preference, undervalued transactions, breaches of fiduciary duties, all of which, Your Honor, swells the assets available in a liquidation.
Mm.
Next, last sub-point of this argument is that we've heard about the proprietary trades taken up by Wang Li. Now, Your Honor, one must assume that when Mr. Wang engaged in those proprietary trades, he did it for a profit motive.
Mm.
We were told, Your Honor, the aftermath of the crypto winter, monies were lost, huge losses were made by Mr. Wang. But what about profits made before June 2022? Nothing has been disclosed. No investigations. Houlihan Lokey has not looked into this. The IFA has not looked into this as well, Your Honor. Everybody is pretending that nothing of this happened historically. So, which is why, Your Honor, my first point is that it's meaningless for a liquidation versus scheme comparison to be made when there is no historical financial information being provided. Any meeting that is convened will not be fair to the creditors, Your Honor. That's my first point, Your Honor. My second point, Your Honor, is that there has been a lack of candor and selective disclosures. Your Honor would perhaps be surprised by this statement because my learned friend has made statements to the effect that they have made even adverse disclosures. I would say, Your Honor, the applicant has highlighted matters in an independent financial advisors report that supports their position. But there are also matters, Your Honor, that they need to highlight to Your Honor, which are material to the creditors. And I think it's important to highlight a few because the IFA report is actually buried in a mess of 400-500 pages of documents under an originating application.
Mhm.
If I could, Your Honor, just bring Your Honor to IFA report, which is at ES 211.
Sorry, which bundle are you using?
I am using the originating application itself, and I believe The IFA is actually in Appendix D of Annex B.
All right, hold on a moment, please. Hey, what page again?
Your Honor, the IFA report is at ES 207. I believe ES is the pagination at the bottom right corner.
Sorry, I think my bundling numbering is different. Hold on. This is Annex B, correct?
That is right, Your Honor.
Your Honor, just to assist, at the bottom right of each page of the explanatory statement, there's a ES dash number. For convenience, would it assist if everybody referred to that number, Your Honor?
Yes, all right, fine. ES 207, was it?
Yes, Your Honor, that's the IFA.
Oh, hold on. Hold on, sorry. Don't have that on the e-copy. Hold on a moment, please.
Your Honor, I'm not sure.
Hold on, please. Just hold on a moment, please. What is this? Hold on. Sorry, Mr. Yo, is it contained in any other affidavit or bundle, please? Could you give me a reference? It was somewhere else, right?
Your Honor, it should be in the first affidavit of Yang Zhou.
So what was the date again?
The first affidavit was on the 30th of August.
30th August. All right. Hold on. I'm sorry, I'm sorry, Mr. I have some difficulties with the e-copies. Hold on.
Oh, sorry. My apologies, Your Honor. It was only annexed to the originating application.
Yes, I have some problems bringing it up. Hold on.
Your Honor, it is also in the letter to court of 18 September.
All right.
I- Otherwise, Your Honor, I'm happy to flash it on screen. For
Hold on, please. Sorry, it's your letter of 18 September.
That's correct, Your Honor.
Hold on. Hold on, we'll stand out for a few minutes. I'm having some problems with my elite copy. All right. Hold on. Any stand down for a while.
Yes. Please adjourn.
All right, sorry, I had some difficulties. I've got the documents up. Sorry, you got page 267, Mr. Chu?
Your Honor, 211.
211, sorry, hold on a moment, please. All right, carry on, please.
Yes, Your Honor. 211 is the IFA's comments on Holohan Loki's liquidation analysis. Your Honor will see the second paragraph on the top is that the IFA notes that there is a limitation to HL's analysis because of the consolidated nature of their common set of wallets. The movement of funds within the group was not considered a transfer of assets between the different debtors. The IFA went on to say that if such movements were applied to the existing allocations, they could potentially have a material effect on the loans in surplus deficit of the debtors, and therefore the impact of returns to the creditors, Your Honor. And then, Your Honor, we go on to the next para, the third line from the bottom, that starts with the outcome from individual liquidations could therefore be materially different if cross-currency and product set-off does not apply to the accounts as anticipated by Holohan Loki. And then, Your Honor, we'll go straight to the conclusion at page ES 213. This is the conclusion on HL's liquidation analysis, and that's what the IFA said. First, under the paragraph under conclusion, third line, absent a detailed forensic analysis of the allocation of assets and liabilities, source of funds
Sorry,
used.
what line? Sorry, which paragraph and what line?
Your Honor, the second paragraph from the bottom at page ES 213.
Right.
The paragraph, Your Honor, starts with the estimated return
Okay.
under conclusion.
All
When
right.
we go to the third line, that's what the IFA says. That starts with absent. Absent a detailed forensic analysis of the allocation of assets and liabilities, source of funds used to acquire the investments, and a comprehensive legal review of the potential wrongly litigation, we consider that HL's liquidation analysis represents a reasonable representation of the estimated outcome in liquidation scenario. So the point, Your Honor, is that the IFA did not give an entirely positive conclusion as to HL's report. In fact, the IFA actually pointed out that there are certain deficiencies in HL's reports, which, makes them, in effect, caveating their conclusion on the HL liquidation analysis. Your Honor, if I could go on, 218 of the same report, Your Honor sees this is actually a conclusion from continuation from 217 under the header proposed releases to Yangzhou. And then Your Honor goes on to ES 218, the third paragraph from the top. So that's the paragraph on the top that starts with certain creditors. If Your Honor sees it, certain creditors have expressed serious concerns about the state of the debtors' financial records and poor corporate governance in the evidence filed in relation to the moratorium applications. So the IFA noted this. And the IFA then goes on at the bottom of the paragraph and he says, but consideration should be given to disclosing further details to creditors in the scheme documentation. So that's what the IFA told the paper group. And if we go further down, Your Honor, the next paragraph talks about the RXTS and HX debt. Do not disclose any direct consideration to be provided by Yangzhou. I think it's Yangzhou, not Yangzhou, in exchange for its proposed release. The IFA goes to say we have also not been provided with any information relating to his personal financial affairs to assess if he would be a worthwhile litigation target. And effectively, what the IFA is saying, if you go on to the next paragraph, we notice, Your Honor, that in fact, there were legal opinions raised. Next paragraph, we have reviewed preliminary assessment provided by the group's legal advisors of potential legal claims against Yangzhou under Hong Kong, Singapore, Cayman's law, and BVI. Those preliminary assessments were provided on a confidential and privileged basis. This assessment include consideration of potential claims in relation to one, Your Honor, the proprietary trading activities in respect of Yangzhou. Two, the pooling of crypto assets of the group members on a consolidated basis and opening consolidated accounts on crypto exchanges and the cipher repurchase. So in fact, there is a potential cause of action against Yangzhou for all these three matters, for which, as far as we can tell, legal opinions have been obtained. And if Your Honor goes to the next page, at page ES219, right at the top, it's a continuation of the previous page. But what the IFA is saying, top paragraph, second line, towards the end, based on our review of all available information, we do not consider it will be unfair or unreasonable in the current circumstances to enter into releases with Yangzhou and allow the restructuring of the group to proceed. But they qualify it again, Your Honor. However, this is essentially a trade-off for creditors between the opportunity to pursue claims or a superior estimated return from the scheme. And it will be for the creditors to decide on the appropriate weight to be given to each objective. Your Honor, that's precisely the point, that no information is provided to the creditors with respect of what kind of claims and the quantum of the likely claims against Yangzhou would be. In fact, we don't even know what is Yangzhou's personal finances. We don't know what the quantum of this claim is, but all we know is Yangzhou promised to put in 20 million. We don't know for certain, when you match dollar for dollar, whether the 20 million really outweighs the potential recovery that we can have against him. But the point is this, no information is given to creditors for them to weigh the options, Your Honor. So that's what IFA is effectively saying. And if I could just go on, Your Honor, very quick one, 221, that's the management contribution. And the next page is 222 with regards to CVRs. Your Honor, the fundamental plank of this restructuring is that there would be issuance of what we call the Babel recovery coins and the CVRs. And Your Honor, the Babel recovery coins is in essence something that's currently worthless, but it potentially might generate returns if the management contributions goes into the sinking fund. And the management contribution then appears to be based on the future performance of the new business. Your Honor, this is what the IFA has to say about the management contribution, Your Honor. Your Honor goes, the paragraph, if Your Honor sees the header management contribution at page 221, Your Honor sees that main paragraph that talks about the level of the estimated returns. But if I could just focus on para Roman 1 and Roman 2, this is what the IFA says. We understand under 1, we understand that the income projection assumptions are based on both historical performance of group business and market trends, open bracket, as management continues to monitor the broader market. The next qualification is important. However, we have not been provided with detailed assumptions behind the income projections for both the C5 and D5 business. And we have been unable to form a view on whether the methodology used to arrive at the income projection is appropriate and captures market and risk factors in the crypto industry. And then Your Honor goes to Roman 2. Limited information has been provided in relation to the key variables, such as the number of new clients acquired, increased interest margins, yada, yada, yada. And it ends again with the sentence, but no further details have been provided. And if I could bring Your Honor to the next page at V, Roman 6, at page ES222, Your Honor sees further, I suppose, disclaimers by the IFA. Third sentence, the second line, we note that although the Hope Swap business launched in April 2023, none of the projections are based on actual performance, as the figures only reflect a Q3 2023 start of the business. The projections are based on management expectations that hope swap business will grow exponentially for the next few quarters and will benefit from increased opportunities to acquire market share. And then they said, we cannot form a view around these projections without having a more detailed business and financial plan for achieving that. And then finally, Your Honor, after all the Roman paragraphs, we go on with a paragraph that says, as the model assumptions provided are based on management expertise and expectations, and there is an absence of detailed business plan underpinning the projections for the new business, we are unable to offer a view as to whether they represent a reasonable basis for the estimated recoveries under the scheme. And finally, Your Honor, just to round off this point, at ES 223, this is the IFA's comments at ES 223, third paragraph from the top. Does Your Honor see the paragraph that starts with, we have reviewed the HL valuation?
Yes, right.
And then Your Honor just goes straight to Roman 3. As noted above, in relation to the management contribution, the projected revenues, especially in the upside case, average revenue of 800 million per year and reaching the sinking cap in 7 years, appear highly optimistic as they assume 200% the revenue of the DeFi business in the base case, reflecting a scenario where the DeFi business is highly successful. As noted above, we cannot offer a view as to whether these projections are reasonable in the absence of a more detailed business plan. Your Honor.
So, the basic reports that I would assume would be this is for the creditors to take note of and for them to read and to make their own assessment about whether they think these are shortcomings that should make them pause and not vote for the scheme.
Well, I suppose, Your Honor, there might be a different, there's a deeper level to that, I suppose. And the point really is that if you couple this with the lack of financial disclosures, which is the first point I made earlier, the apparent lack of motivation to find out where the company's monies went, and the IFA's concerns as to whether this scheme that is now being proposed is even reasonable and valid. I think the concern we have is this, that first, our monies as creditors have been punted by Babel Finance. After making a punt and they lost, they are now offering us a plan where their own IFAs are saying might not be feasible, thereby inviting us to take another punt with them with a view of trying to recover monies already lost. So I'm not sure if that's actually a commercial decision or really that's something that underpins the entire viability of the scheme.
Right, but in terms of the tests that we have at the convening stage, how do you say that this shows that Babel hasn't even met one of the requirements? Which requirement have they fallen short of, and how, and what would be the effect of that?
Well, Your Honor, I would say they have not met the requirement of providing sufficient information to creditors as required under the test of Pathfinder. They have to provide sufficient information to the court to enable the court to decide whether or not it will be a fair scheme meeting.
All right, so yes, so that would be the appropriate test. So on that basis, then, even though you may have pointed out what you think are shortcomings in the proposed scheme and that sort of thing, could it really be said that the information here is insufficient for the creditors to vote? Because it may be that the information shows that there's something bad about the scheme, and then it's for the creditors to vote no. And that will be for the creditors to decide. So can it really be said that the level of information provided right now falls short of the required standard in Pathfinder?
I would say, Your Honor, the duty is on the applicant to bring out such information to the attention of the court. Your Honor, the duty is really not for an opposing creditor like me who throw through 500 pages.
Yes, so my point is not really about whether the information is sufficient or otherwise, but it's really whether is there sufficient information given so that the creditor can decide. And the creditor may go along with your position and say no, but isn't all the information there? so to speak. So if they've fallen short, then it's up to the creditors to vote. Some creditors may disagree with you, but that's really something to be resolved at the meeting.
Well, I would say, Your Honor, I agree with Your Honor, subject to one qualifier, which is the same point that the IFAs have pointed out, which is that there is no detailed business plan at all.
All right. And you say that's something that Babel should actually put forward at this stage.
That is correct, Your Honor, so that we actually know what we are buying ourselves into in exchange for our debt. That is the second point that I'm making, Your Honor. The third point I'm making is on classification. Your Honor, the problem with classification really is like what my learned friends have said. There are, in effect, at least 2 or 3 separate lines of business that's being carried on by Babel Group. And it's not just a question of the business, but really because of how the various creditors, so to speak, dealt with Babel Finance. In my client's case, as well as I believe Marita's Law's client's case, we actually transferred our assets to be managed by Babel Finance. So what we do know now is that there has been a loss of our assets because of certain proprietary traits. And arising out from that, Your Honor, we say that we have at least a good arguable case of dishonest assistance against people who have caused this situation to occur. And in fact, I would say, Your Honor, for Paris State, we've gone to the High Court, we've gone to the Court of Appeal, we've gotten a Mariva injunction against Mr. Wang. And that itself is an affirmation that Paris State actually does have a separate cause of action, which is good and arguable for breaches of fiduciary duties or for breach of trust against Mr. Wang. So that
Sorry, I lost you a bit, Mr. Chu.
Oh, I'm so sorry, I accidentally muted
I
myself.
think you need to repeat your last couple of sentences.
Yes. So, Your Honor, my point is that our right against, we have a valid cause of action against people like Wang Li for dishonest assistance. It's been affirmed on various times by the High Court and the Court of Appeal. And to the extent, creditors like us stands in a slightly different position from other unsecured creditors, because we have an additional right that those other creditors do not have in a liquidation situation. So if we are forced, Your Honor, to vote with all the other creditors who don't have that right, and the result of that is that we are outvoted, then we potentially lose our claim against Mr. Wang, because our fundamental claim against Babel Asia would have been compromised.
So you will really be the class of 1 on your own?
No, Your Honor, there are actually other creditors who also gave their assets to be managed by the Babel Group. And one example would be, I believe, Mr. Sean Chung's client, where they have also identified themselves as a creditor who had given crypto to Babel Asia to manage as part of their asset management plan. And he's clearly not the only one, Your Honor. So that's where we are, and that's exactly another reason why, Your Honor, we say that we've not been able to get in touch with other creditors and find out their position. And on that basis, Your Honor, we say that we shouldn't be classed together. All creditors who stand in a similar shoes should be in a separate class. Next, Your Honor, the deed poll arrangement. Very short argument. The argument really is this: different creditors have contracted with different entities. And my learned friends now say that since everyone is going to get close to zero recovery, well, the difference in terms of recovery is not too material. So everyone is in the same situation, regardless of who you contracted with. I think, Your Honor, the point is this: where the recovery rate is already extremely low across the board, a difference of 1% might well be significant in that context. And in a situation where we are talking about many millions of dollars of debt, a 1% difference, Your Honor, might well be $1 million. And it's a bit difficult to say in this kind of situation that 1% is really insignificant. So ultimately, Your Honor, the reason why we are told a deep poll has to be done is because the controllers of Babel had commingled assets across the entities. And we say that is in itself serious corporate mismanagement. And it seems illogical to us that such corporate mismanagement has now become some sort of virtue in support of a deep poll arrangement. Which is why, Your Honor, I think some of the creditors have said that it's effectively a whitewash exercise to force creditors to come together and, release the controllers from all responsibility. And I'll close off this point with my fifth argument, Your Honor. We think that somebody should bear responsibility for what has happened. It cannot be swept under the carpet. I've had the benefit of reading a letter from my learned friend, Mr. Chung's firm, where they express their lack of confidence in Mr. Young's continued management under the scheme. Your Honor, I'm so sorry, Your Honor. In one of this, in a debtor in possession kind of situation, scheme like this, it is important, Your Honor, that there is confidence in management. And when one couples this with the fact that Babel themselves obtain legal opinion on potential claims that they have against Mr. Young, that raises questions of conflict of position and raises question of whether Mr. Young is actually the person who should remain in management in the first place. Especially, I must highlight, Your Honor, one of the legal opinions talks about whether Mr. Young has any potential liability exactly for commingling assets of different clients and their own assets. So that's effectively all we have, Your Honor. I would say, in response to Mr. Andrew Chan's argument that, well, if we can have a deed poll in a liquidation, why not have a deed poll in a scheme? I agree. But, Your Honor, the point is this. If there are so many questions to be addressed about what has happened in the company and the lack of confidence by creditors in Mr. Young's continued management of the company, I would say perhaps a more appropriate avenue, Your Honor, might be a judicial management or even a liquidation instead of leaving the company still in the hands of Mr. Young. That, Your Honor, are my 5 points I have to make on.
All right, thank you, Mr. Chu. Sorry, then turning to Mr. Chung.
Yes, Your Honor, thank you. In this regard, we just want to highlight the commercial unfairness that is evident in the scheme of arrangement that is being proposed by and in this regard, the classification of creditors is evidently commercially unfair because for our client who entered into a similar contract with that of Paris State, we deposited our monies, which amounted to 5 million of USDC cryptocurrencies with Babel Group, and we were promised a certain amount of interest that is to be returned. However, this was not paid to our client, and simply because it came to pass that Babel Group lost possession of the assets that were to be managed by them. And this is why we say that it is commercially unfair, because it has also been found out that Babel Group was engaged in proprietary trading and also commingled our clients' funds with the rest of Babel Group. And also because our client was not party or had information about the proprietary trading that Babel Group engaged in, and they did not fully know the risk of such trading, and they should not be classed together as one set of creditors.
All right.
Thank you, Your
All right, thank you, Mr. Chung. All right. So, Mr. Yo, Mr. Chan, we're coming to about 12:25. Can you respond, please, about 20 minutes or less?
Yes, we will keep to that timing, Your Honor. Your Honor, I think Paris State has raised 5 issues. First, let's deal with the issue about historical financial information. Essentially, their question is, where did the money go? Where did all of this money which had been raised beforehand, where was it paid out to? And the simple answer to that is already set out very extensively in the OA 192 affidavit back in March 2023, when we first filed for moratorium. We expressly stated exactly how much had been lost by reason of the proprietary trading activities. We expressly stated how much had been, that there were margin calls and how that affected the group. And we expressly stated how much had been lost, or rather that there were significant losses, which we did quantify in relation to the set-off exercise which had been conducted by derived, which is of course disputed by us. So first of all, in terms of where the money went to, we had provided exactly the disclosures which had been sought. The next question that they ask is, okay, are there then potential clawback claims against directors or management? First of all, we had expressly disclosed the post-gate raise payments, which were not even to the directors themselves. So that, Your Honor, I will just give Your Honor the point citation for that. That is in the first affidavit of Yang Zhou at paragraph 57. I don't intend to take Your Honor to it. In March 2023. Second, Your Honor, we had specifically disclosed that nothing had been taken out from June 2022. Nothing had been paid out to the directors or the management. And that was in response to the precise request which had been made by Parastate that there be disclosure of money paid out to directors or management at the date of or just prior to insolvency. So therefore, because withdrawals were suspended because of the market crash and so on, withdrawals had been suspended as of 17 June 2022. We then took the entire month of June 2022 to give disclosures in relation to. Having given that disclosure, Parastate is now changing the goalpost on what should be disclosed, and they're saying that that date of June 2022 is not enough. Your Honor, I don't think that's a fair criticism because we provided exactly the information which had been sought. Third, Your Honor, even if all of that disclosure were not sufficient, the independent advisor's report specifically assesses potential claims against directors. Again, Your Honor, I will just give Your Honor the point side because in fact, my learned friend had himself referred extensively to the entire discussion on potential claims against directors. So the point site is ES 218 at Annex B. That's of the OA 881. That is the explanatory statement, page 218. So, Your Honor, it cannot be said that we did not provide sufficient disclosure of potential clawback claims or historical payments made to directors, because that is exactly the very analysis which Parastate is then latching on to raise other criticisms. As for issues in relation to Mr. Wang Li, which Parastate raises, they essentially say that they have dishonest assistance claims against Mr. Wang Li, and that puts them into a different class. That is incorrect, Your Honor, because any dishonest assistance claim against Mr. Wang Li is not affected by the scheme at all. The relevant test as to classification is as to how your rights are affected, whether in relation to the company or as affected by the scheme. If the scheme does not affect that claim against a third party, then there's no reason for you to be put into a separate class. Now, let's turn to their other questions about class, which was, they then said, oh, we potentially have claims against Yang Zhou. But the reality is, Your Honor, that they did not get a Mareva injunction against Yang Zhou. They only obtained a Mareva injunction against Mr. Wang Li. And in fact, they didn't even seek one against Babel Finance. And even then, they didn't commence any arbitration proceedings, despite being subject to an arbitration stay. So as for how strong or weak their dishonest assistance claims are, I will leave that for Your Honor to judge.
Mr. Yos, even if there reliance on the claims against Mr. Wang are misplaced, wouldn't the same set of circumstances indicate that they may potentially have some other claim or interest against the applicant companies, or at least some of the applicant companies, that would put them into a different position vis-a-vis the other creditors?
Yes, Your Honor. They may have claims against Babel, and I'm not precluding that. In fact, they have a management agreement which provided for the management of assets. And I don't believe it's disputed that the management assets have been lost. So there is a potential claim there, but at best it is an unsecured claim. I believe Parastate itself has expressly asserted in their submissions and in their affidavit that the management assets have been lost.
Yes.
And by the basic legal principles which Mr. Chan brought you through earlier, that is not a trust claim. That is at best a claim for equitable compensation, i.e. an unsecured claim.
Yes. So, but even then, even if it's an unsecured claim, couldn't that potentially be a different class of claims from the other unsecured creditors?
How you treat it compare it.
Or at least the ones who have a management claim may need to be classed separately from the other unsecured creditors?
In my submission, no, Your Honor, because the percentage recovery is the same. The fact that it is an unsecured claim is the same. Just the mere fact that it is, for example, a claim for equitable compensation as opposed to a claim, a contractual claim for the return of crypto that other creditors may have, does not necessarily put them into a different class.
So you're basically saying that the recovery by these creditors in the same position as Parastate would not be any different from all the other unsecured creditors without such a claim?
Yes, because percentage recovery is the same, and the fact that it's unsecured is the same.
But the percentage recovery, wouldn't they have a different overall claim, overall quantum?
Your Honor, their quantum may be different. But
Percentage is the same.
Yeah, the outcome would be the same. If they were to be ranked in a liquidation, creditors would be who claim equitable compensation would rank as unsecured creditors.
I'm trying to figure out what would they actually be claiming at the end of the day, assuming they succeed. So that goes to my mind to question whether they can be said to be in the same position as all the other creditors. So would these, let's call them the Parastate creditors, really be in the same position as everyone else? Would they be claiming X percent as everyone else, or would they be like X percent for some of the quantum? So say it would be X percent.
I think it would still be X percent. And I think what Your Honor is saying is how would their claim be quantified? Essentially, Parastate have themselves quantified their claim as the amount of the management assets which they have pumped in.
And nothing else, right?
Sorry?
And nothing else.
And nothing else, Your Honor.
All right.
But perhaps interest and cost, but that's
All right, hold on a moment. Let me just record this. All right. All right, Karen, Mr. Yo.
Thank you, Your Honor. Your Honor, I'll turn to the next point which my learned friends representing Parastate had raised. Essentially, they're saying that the independent assessor's report is caveated, or the conclusions are caveated. First of all, I thank my learned friend for going through that, because that is exactly the disclosures which we had raised before. The conclusions are caveated because, as they first pointed out, Your Honor, I'll just give Your Honor the point site at ES-211 of Annex B. They pointed out that intra-group transfers are expensive and difficult to unravel. This relates to commingling, Your Honor, or the fact that the group had operated on a consolidated basis and had mixed the crypto and other assets. We had disclosed that, Your Honor. Second, Your Honor, they say the conclusions are caveated because of the potential existence of claims against Wang Li. Again, we are not releasing Wang Li, and we highlighted the exact same issues and same potential claims and same potential wrongdoing, in fact. Now let's turn to the third thing which they pointed out from the IA report, which is essentially potential claims against Yang Zhou himself. Now, this is dealt with at significant length in the IA report, precisely because I believe Ellen and Gladhill can put our neck out here to say that we recommended that if you are going to grant any third-party release in a scheme, the IA's assessment needs to expressly go into whether there are any potential claims and the impact of that potential third-party release. And that's exactly what has been done in ES 218, ES 217 onwards. That it has gone into significant detail on whether there are any potential claims and whether the third-party release is fair. Now, their specific complaint at ES 218, if Your Honor is with me there, is in relation to the third paragraph from the bottom.
Yes.
That legal advice has been sought by the group's legal advisors, assessing potential claims, including, and note that it is not limited to these three, including proprietary trading activities, pooling, and the cipher repurchase. Now, none of these legal opinions have been provided to creditors precisely because they are privileged and confidential. I believe that much is fair for the companies to take that position. However, Parastate then goes on to misrepresent the effect of these paragraphs to assert that there are actually claims for these three items: proprietary trading, pooling, and cipher repurchase. That is significantly unfair, Your Honor, just because the legal advisors and the independent assessors specifically identified that these are things which were included in the analysis does not mean that the contents of the advice then said that there were actual claims which should be made and that there was actual wrongdoing. In fact, as Your Honor would be aware, Yang Zhou was not even involved in management at the point in time of Roman numeral 1 and 3. So, Your Honor, the fact is that, first of all, as a matter of disclosure, we had expressly disclosed sufficient information, in fact, I would say more than sufficient information, to creditors to let them know what are the issues involved in granting this third-party release. And second, despite going through all of the analysis here and the legal advice and the analysis in the IA report, the IA report still concludes on the next page, 219, that based on our review of all available information, third line from the top, we do not consider it would be unfair or unreasonable in the current circumstances to enter into releases with Yang Zhou and allow the restructuring of the group to continue. And just to make sure that creditors are aware that there really is a trade-off which they're being asked to enter into here, the IA report expressly says this is essentially a trade-off between the opportunity to pursue claims or a superior estimated return from the scheme. And it is for creditors to determine the appropriate weight to be given to each objective. So, Your Honor, I think this is the point. We have given the financial disclosure necessary for creditors to make their assessment. Your Honor, I see I have 5 minutes left. I'll just wrap up two very quick additional points. Parastate next raises that there are a number of caveats in relation to the new business and the new business projections. I'm very happy that they highlighted that because it shows that we have in this very specific papers given to creditors provided all of the risk factors in relation to the new business. Any new business is hard to project, Your Honor. But the fact is that this crypto business is particularly hard to project, and that is something which needs to be highlighted to creditors, and we have done that. But, Your Honor, that goes to the commercial merits of the new business. That is for creditors to decide. Having been provided with the exact disclosures and exact disclaimers which Parastate itself has highlighted, and we have highlighted. Last of all, Your Honor, if Your Honor needed some indication of valuation or indication of the veracity of these projections, we have obtained $39 million in new money commitments towards this very same business model. And at the bottom of page ES222, the independent advisors accept that the new money has been pumped in on the basis of that very aggressive, by their own words, $275 million base valuation. And that's the valuation on which new investors have pumped in money. So, Your Honor, yes, I acknowledge all of the risks. And in fact, that is exactly what we think we have done, which is fully disclose the risks. But we have also shown the court that there is something of merit here, if the court were even inclined to go into the commercial merits of the new business. Your Honor, the last point that I would make is in relation to confidence in the management and the business going forward. First of all, Parastate raises the suggestion that there is some kind of conflict of interest in Mr. Yang Zhou proposing the scheme or being debtor in possession or being the face of the company and getting a third-party release. Your Honor, that is unfortunately the nature of debtor in possession restructurings. But I would also highlight that there is a further layer of no conflict here, because the legal advisors which have been engaged and the other advisors which have been engaged to act for Babel do not act for Mr. Yang Zhou personally. He has separate advisors. And that is a very clear distinction in legal representation. Meritus Law then says that in their letter and elsewhere, and in today's hearing, that they have no confidence in the safeguards and measures taken to segregate funds or in the corporate governance in the new entity, and Parastate has latched on to those comments as well. Your Honor, with respect, I believe that both creditors have appeared to miss the point, because numerous safeguarding factors and segregation measures have been put in place and proposed. Your Honor, I will just take Your Honor to that. Sorry, I'll just give Your Honor the point side because of time. ES 226 has the IA opine that creditors have queried what safeguards would be put in place. We understand that the group is partnering with regulated custodians to safeguard client assets such as Coinbase and so on. Client assets will be stored in segregated cold wallets and so on. So that's ES 226 as a point side. At ES 232, we set out the legal and compliance framework enhancements which we intend to adopt going forward. At ES 234, we set out the proposed corporate governance model for the new business, including the establishment of a dedicated monitoring committee. At ES 235, we set up an updated internal risk management framework. Your Honor, at ES 236, there's a further set of descriptions of the team of governance and compliance which will be put in place. So, Your Honor, with respect, I believe these two creditors have entirely missed the new framework which has been set out in the explanatory statement. No fault of theirs. It is a very lengthy document, but and I'm grateful to them for having raised the issue so that we can highlight this here. Your Honor, the very, very final point I will make, I realize I'm a little bit over time, but the very final point I will make is creditors' positions in terms of amount of support and amount of opposition. In support, at the 6th affidavit of Yang Zhou, filed in these proceedings, dated 18 September.
Yes.
At paragraph 11 to 12, we set out that we have received 28 letters of support, totaling 17.7% in value. That's just over, I believe, if my math is right, $230 million in net value, not gross value. Just today, and this is new, Your Honor, we have received confirmation from 3 more creditors, that is Genesis Global Capital LLC, Zipmex Asia Private Limited, and Zipmex Private Limited, that they have either no objections, that's for Genesis, or that they support, that's for the 2 Zipmex entities, the convening and moratorium applications. These are major creditors, as Your Honor would have seen from the top 20 list of creditors, which was provided to Your Honor.
Zip Max is before me in other proceedings, Mr. Yo, I'm not sure how far that can go. All right, anything else?
Yes, in comparison, just final point on creditors' positions. The three opposing creditors, being Derived, Parastate, and Smarty Labs, represented by Meritus Law, total at best 2%, maybe 2.5% of net total claims.
All right, then, thank you. Hold on, before I end, Mr. Chu, can I turn back to you? Could I ask you to state for me what you think your claim would be, let's say, for breach of the management contract or whatever other interests you say you have vis-a-vis Babel?
Your Honor, as of OC 130, the claim has been brought by Parastate as against Mr. Yang and Del Wang for compensation for breach of for dishonesty assisting breach of fiduciary duties on the part of Babel Asia as well as Babel Holdings. Insofar as OC 130 is concerned, Parastate has not made a monetary claim as against Babel Asia and Babel Holding for the simple reason that at the time when the lawsuit was launched in June, we knew that the Babel Group were already hopelessly insolvent. So in the event that this scheme is, I suppose the scheme meeting is convened and we are all asked to vote, then what happens is that Parastate will then have to file a proof of debt stating that it is claiming for the return of the 5 million, I believe, USDT that Parastate has actually transferred to Babel Asia. So to the extent while we'll file the proof of debt, we'll also have to indicate the equivalent value in fiat currency. But effectively, we are claiming for the return of the coins, Your Honor.
Yes, because I'm trying to see whether there's a way to formulate your interest here, which might lead to different position from, let's say, other creditors who have not gone through the same transaction as your client. On that basis, what do you think would be the primary differentiating characteristic or quantum in your case?
I would say, Your Honor, in a typical liquidation scenario, my client's recovery, as with all the other creditors, would be close to zero, but we would have ability to recover the 5 million from Wang Li in a liquidation scenario. Whereas in the scheme, as what we can see here, we have to compromise our claim as against the Babel Group. The effect of that, Your Honor, is my learned friend takes the position that, well, we can still go after Mr. Wang. But one would anticipate an argument from Mr. Wang that, look, your loss has effectively been compromised in the scheme. You will therefore have BRCs, which, you accept is in exchange for your 5 million debt that Babel owes you in the USDT. So considerably, Mr. Wang will then raise the argument that therefore you have suffered no loss for which you can come after me for dishonesty assisting in the breach of fiduciary duties. That, Your Honor, is, at least from our perspective, the differentiating factor.
There's your delta vis-a-vis the other creditors, the loss of
That
the
is correct.
against Wang.
That is correct, Your Honor.
All right, thank you. Mr. Chung for Smarty Labs, anything else to add on this point? Nothing, was it? Sorry. Chung?
Sorry, Your Honor, if I could just have 1 minute to review the submissions that have been made.
All right, thank you.
I apologize.
Just on this point.
Yes, sir. I'll just need 1 minute.
Yes.
Your Honor, perhaps in that 1 minute, I would just say one thing with Your Honor's permission.
All right, Mr. Yo.
The law is very clear that schemes do not release claims against third parties unless the scheme expressly provides for it. I can provide Your Honor authority for that.
All right, that's all right. Thank you.
Your Honor, if I may.
Yes.
Yes, I think there could be a possible differentiation on the classification of debts. For example, let's say the cryptocurrency coins were transferred and commingled between the groups. And for example, BAA and PLs who was holding on to several cryptocurrencies have transferred them to another entity of Babel Group, such as Moon Alpha. Through proprietary trading, Moon Alpha would become a constructive trustee of these coins, and that could possibly lead to a different set of legal claims against them.
All right. Thank you.
And in such situation, a cross set off would be unfair. Thank you.
All right. Thank you. Mr. Yeo, any final reply on this point?
No, Your Honor. Thank you.
All right. So you rest on your previous arguments on this issue. All right. All right. Thank you all. As indicated, I will need time to consider some of these points. So tentatively, I hope to give a decision in about 2 weeks. Registry will confirm the date. Mr. Yeo, if any issues come up in the meantime, any commercial or other imperatives make the timeline a bit tighter, please write in to let me know. All right.
Thank you, Your Honor. We will do so.
All right, thank you then, all. Good day, and I will see you in about 2 weeks. Registry will write to inform. Sorry.
Yes, my humble apologies, Your Honor. I indicated that
sorry.
Prayer 6, the independent assessor
Yes.
matter, we have not yet named an independent assessor. With Your Honor's permission, we may write in during the 2 weeks.
All right. Yes, so you can indicate to me thereafter. In the meantime, I'll grant a interim moratoria to the next hearing.
Thank you, Your Honor.
Interim moratoria extended to next hearing.
Thank you.
Good for you.
Grateful. Thank you. Good day.
Good day, Your Honor.
Good day, Your Honor.